guys, let's take a look at some of the stuff that's been going on in the Richard Allen case, especially since the Supreme Court decision on the writs there. It's been a lot of litigation, but no movement towards trial, really. Nothing that's changed since before that. The date, I think, still set for October, but nevertheless, it's been very active. Let's take a look. Make this bigger so you can see it. All right, so these are some of the things that have happened, and we'll just kind of go over them. It's possible I missed something because you can see the list is pretty long. The judge denied the Franks motion. I'm not surprised by that. I think any judge would have denied it. I get the grounds for it. 95% of it was really irrelevant to the Franks standard, in my opinion. Some of it was relevant, but I don't think it rose to the level it needed to suppress that search warrant and make that invalid. And really, what does that come down to? I think all we know so far that is potentially relevant from the search is the firearm, right? Maybe there's something else, but all that's mostly been talked about is the firearm, and that's debatable, right, of course. And then the motion in limine regarding ballistics, that was denied, and that's also regarding the firearm. Not really ballistics because it wasn't a fired cartridge, but it was a recovered cartridge from the scene and a case matching by tool mark analysis. They asked for that to be excluded prior to trial. The judge said no. That doesn't mean it won't be excluded later, and it doesn't mean if it comes in that it has to be considered by the jury as compelling. There's a lot to look at there, and it's certainly debatable whether it is or not, but it's not surprising that it was denied at this point. That's entirely in accord with the case law in that state. There was a motion to withdraw from the attorneys who'd been appointed. That was granted, of course, by the judge, not surprisingly. And, you know, there were some people who hated them from the beginning, thinking they were put there by the judge simply to rubber stamp whatever she was going to do, but they didn't do that. Instead, they filed some documents that were essentially consistent with the first set of counsel, saying that the conditions he was being held under were impairing his ability to defend himself, which I can certainly understand that, and I don't understand why he's being confined the way he is at the distance he is, and expected to be able to mount an effective defense. Even, you know, he's not guilty yet, right? That's what the trial is supposed to be for, I think, at least, isn't it? And so it's kind of extraordinary to have him being held like he is. And it's interesting that you've had all these defense counsels say the same thing. So if you think he's guilty, maybe you don't celebrate this too much because it could be an issue for appeal later. But, you know, that's way down the line, and it's just an opinion. It's not one the judge shares because she has denied these motions to transfer. All right, there was a motion to compel discovery that was granted, a motion to disqualify the judge, and she denied that on the basis of what the Supreme Court had said, and we'll hit that with an actual slide here in a minute. Then the state moves to hold the defense counsel in contempt, and I don't know about that. You know, that's going to litigate this issue again, the same one that they were kicked off the case for, right? That the Supreme Court said you can't take them off the case. I think it's basically the same conduct. The state is saying we'll find them in contempt. Is that really going to help this case along? I don't know. The motion to transfer, I mentioned that. I think that was denied. That was to try to get him out of the prison that he's in. And then some of these things we'll go over in slides. A motion to dismiss for destroying exculpatory evidence. That's by the defense. That's very interesting. And then a motion to deny the state's information. That's for the contempt hearing. That's also interesting. Clarification, discovery, and motion to allow electronic device. That's just the defense counsel asking to be able to bring some devices in. And then depositions and subpoenas related to this contempt hearing as the defense tries to fight back, saying we need to be able to talk to the people that you're saying you're going to use to support the fact that we did all these allegedly bad things. So again, we got a lot of litigation that isn't really related to the merits of the case, but it is what it is. So let's move on. So this is from the Supreme Court written opinion talking about the request for writs. Here we explain our reasons for the three decisions. In short, we reinstated Baldwin and Rozzi as Allen's appointed counsel because the trial court did not find their disqualification was a necessary last resort after weighing the prejudice to Allen. So the Supreme Court here sets down, I think, a very reasonable standard. It was not exactly what the state said, and certainly not what the defense said, which they didn't need to say, which was basically you kind of can't remove these people, and the state wanting to make that more discretionary for the judge. Well, the Supreme Court said, no, it's, you know, you can't be a clown on a case and the judge is helpless. But on the other hand, the judge can't just, because they feel like it, just throw somebody off a case and wreck a defense. It's a very reasonable decision. And I think that was anticipated and is wise. They denied Allen's request for a trial within 70 days because he did not make that request in the trial court. That shouldn't be surprising at all. You got to do that. The time frame at the trial court is up to the trial court judge, and if you want them to speed it up, you need to make that motion. And by the way, that motion has still not been made, so maybe the Supreme Court did the right thing here. And they also denied Allen's request to replace the special judge because he did not overcome our presumption of impartiality by identifying facts that showed clearly that the special judge is biased or prejudiced. And we'll look at some more excerpts for that. So I didn't think they were going to win the 70 days. I thought they probably would win the reinstatement. But I also thought because they'd win the reinstatement, the court might say, just to make sure that everything's clear, we're going to put a new judge on this case just for the appearance of potential impropriety. But they didn't do that. And that was an iffier proposition. So it is what it is, and the judge is going to stay on the case, and has certainly been active in it. So on the throwing the people out, the court said the test is whether as a product of a defense right to due process or the right to counsel. The bottom line is this: a trial court cannot disqualify court-appointed counsel over the objection of the defendant and the counsel unless disqualification is a last resort or it's necessary to protect the defendant's constitutional rights, to ensure the proceedings are conducted fairly and within our profession's ethical standards, or to ensure the orderly and efficient administration of justice, and those interests outweigh the prejudice to the defendant. So the judge has to make a record to support throwing somebody off that incorporates all of these standards. And those do have to do, of course, with, constitutional right, of course, but also fair conducting of proceedings and ethical standards, orderly and efficient administration. And so there, the judge does have an option if you were to have lawyers on board that were doing completely wild things and stuff like that. The court, of course, could throw them off. Anybody who thought that wouldn't be possible was not really thinking, I think, about the ramifications of what they're asking for. So now here's about the bias part. The special judge said counsel made mistakes that rendered their representation ineffective, but her statements were not based on any extrajudicial source or any experience outside this case. Instead, her statements were based entirely on her observations within this case. And while her conclusion that counsel were constitutionally ineffective was too harsh, she wasn't wrong to be deeply concerned that sensitive case materials had leaked. Though she mistakenly hit defense counsel's eject button instead of the case's lockdown button, she was right to try to get the situation under control quickly and decisively. Her efforts did not reflect any bias or prejudice, and Allen doesn't identify anything she has done that demonstrates she isn't impartial, for him at least. We therefore deny his request to replace the special judge. So I think you could see the circumstances differently there to some degree that I did, but this was, I think, a unanimous decision by the court on this issue. So that's how they saw it. So that's the way it's going to be. All right, let's take a look at some of the other things that are going on in the case here, since we got past the Supreme Court stuff. Make sure I have something here where I can read it. Interesting. I have a highlighter on the copy I uploaded, but it didn't show up here, but that's okay. So one of the things that was kind of exciting is the defense said, look, we want this case thrown out because of the destruction or withholding of evidence. And they put this on the first page here. Maybe you'll be able to see it. Under a statute for any other ground that is a basis for dismissal as a matter of law. Now, normally, of course, you want to find a particular thing that supports your request for dismissal. This is a catch-all provision, but a catch-all provision exists to catch things that it needs to catch, so nothing wrong with that. You have to get to the merit of what they're talking about, and if what they are saying is correct, then the statute would support what they ask for. So on the second page here, over on the side of the screen, the Indiana Supreme Court has said a serious breach of duty occurs when the prosecution, willfully or intentionally, when unjustified by public policy, obstructs the access of the defense to material evidence. And likewise, a serious breach. It is a serious breach when, through lack of vigilance, the negligent destruction of withholding of material evidence by law enforcement or other prosecutor occurs. Grounds for reversal may exist. You can't overlook the word may there, because I looked up a couple of these cases that they're even the ones they're citing. One was there was a rape kit, okay, and the prosecution lost it. They lost it, but the judge still allowed somebody to testify in trial about what the results were. Now, the results didn't say, well, this guy did it, but the defense was complaining that we could have done independent tests on that rape kit. but because of the circumstances of the case, the court said, well, it wasn't used to directly tie him, et cetera, and all that. We don't find that it met the standard of materiality, or it wasn't exculpatory enough on its face, so we're not reversing this. And there was another case where there was undergarments that were, I think, lost or not retrieved or something like that from a rape scene. And the court said, well, those things don't necessarily show one way or the other what happened there, so we're not going to throw that out for that. So the mere fact that there could be some evidence, and you might think at this point it's important, don't think that you're instantly going to have a case overthrown or thrown out, or a verdict overthrown. It's more nuanced than that, and you really have to look at what the case law is to understand where they're going with this. But still, they're correct on what they're saying about it. It's just whether it applies or not. All right. So here you can see their brief. This is the defense brief, saying that material exculpatory evidence is defined as evidence that possesses an exculpatory value that was apparent before the evidence was destroyed, and is of such a nature that the defendant would be unable to obtain it by any other reasonably available means. I don't know that this is going to fly, and I don't think it will, because how can you say that these interviews were apparent on their face to be exculpatory for Richard Allen at the time that it was, quote unquote, destroyed, written over on this DVR mistake that they say. There's a big assumption there that it was exculpatory, that value was apparent at that time. It might be potentially useful to them now, and you don't know whether you need it for impeachment or not, because you don't know what these people might say if you call them. But if you don't know what was on it, how can you even say it was exculpatory at that time? That's not necessarily the right angle, I think. But they also have another catch-all that they're trying to get into. I shouldn't say catch-all, but another provision of this. I'm trying to find it on the screen here. So they're trying to say that the item is material if it might benefit the preparation of the defendant's case, or it might reasonably affect the outcome. Then that's a little different here, right? And now it's up to the defendant to establish that materiality, okay, unless for some reason they can't do it because of the destruction of the evidence, but you're still going to have to show the court logically why this thing matters. Just any old piece of evidence that doesn't get collected or somehow is destroyed doesn't necessarily defeat a case. There's got to be this connection here. Now, there is in this case, because they're saying that the two people that they're saying were involved in the crime that exclude Richard Allen, that's the nexus, right? That the recorded interviews of these people are no longer existing. And so they won't have access to the actual statements to prepare their defense, and they won't have those for impeachment purposes. So I certainly get that, but you do have to show that, right? Let's see, I'm still coming off of sickness, so I'm not talking like a normal. All right. Let's move to the last page of what we'll look at here. So here they quote a case here. Duty must be limited to evidence that might be expected to play a significant role in the suspect's defense. And this is from the Supreme Court. Right. So again, you can't have a trivial piece of evidence or pure speculation or something like that and then let a criminal walk free because of that. That's not required under these standards, and it's not how it's been applied under the case law in that state either. So here, I think, and they're not really selling this to me, where they say it is beyond debatable that the evidence here would play a significant role in his defense. It certainly is going to be debated. So that statement's incorrect. Now, whether the debate's reasonable or something like that, I think you'll have to look at. But what the judge is going to look at is, well, if you're telling me that the way the law operates is that we can't even debate this, I'm not going to pay attention to that. We need to look at the context of this evidence and what it might have been, how it plays into what you're talking about. That's what the law requires. So again, I know there's some people who think, well, if there's any mistake made ever by anybody ever in the law enforcement system, then the prosecution should immediately stop. And that may be the world you want to live in, but that is not how the law works. Okay, it's not it's not supposed to be, at least by the law standards, quite that much of a game with that much of a penalty. You're supposed to be preserving the material rights of somebody. So I'm not saying that he necessarily shouldn't win on this, but I'm saying that you can't just show, well, a mistake occurred and therefore throw this whole case out. You're just not going to win on that, and they know that. So they're going to make their argument. Now, do you think Judge Gull is going to throw this case out because this interview doesn't exist anymore? I don't think so, and I don't think probably another judge would either, because it's a little early to be saying that because you don't know whether these people are going to be called as witnesses, what they might say. If they were saying incriminating things about themselves at the time, that probably would have been noted at the time. They might say those things now. If you're really just trying to show that they didn't know Richard Allen, and then you're going to show all this other evidence that shows that they're part of the crime, well, you can still do that. I don't think that anybody contends that at the time they made these interviews to the police, they're like, well, yeah, I was absolutely involved in this crime. I hope you're not recording this. There's nothing like that exculpatory on there. I did the crime, and also Richard Allen and no one else was involved in it. There's nothing like that on these recordings alleged. It's all inferences and things like that. So maybe they still have other routes to pursue what they're after. They certainly did that in their Frank's narrative, right, where they tried to show how these other people were involved in the crime, but not their client, which is the avenue they're going to pursue if this thing ever gets to trial. So all that's to say is I kind of doubt that this is going to be granted. I don't see it. But it's a good motion to make, and it's certainly worth making at this point and maybe renewing again later if they can show the judge during the conduct of the case that their defense is impeded by the lack of this evidence. It makes the issue stronger, and then if it doesn't resolve in their favor, it could become a stronger issue for appeal. So even if it gets denied at this point, it doesn't necessarily mean that you've heard the last of it. All right, let's look at what else we got here. Now here we go for this. The state's trying to hold, of course, the defense attorneys in contempt, something the state moved for pretty quickly after the Supreme Court decision. I don't like this either. I don't like it. The Supreme Court's already said, look, this stuff wasn't enough to throw them off the case. Can we not just litigate this case to a trial one way or the other? Then we deal with the motions to dismiss. They're granted, they're denied. Have the trial, because until you get a verdict or you don't get a verdict, you don't really know what the next steps are going to be. And that's what this case is supposed to be about, right? Not the infighting between the prosecution and the defense going back and forth at each other. So I'm not really a fan when either side does that. And I don't find these guys as bad anyway as what the state has to say about it. But that's just my opinion, and I'm not the one filing the document to find them in contempt. The state did that, so they're firing back here, and I want to point out a couple of things about what they are saying, because sometimes when we discuss these things, and we did discuss it when we talked about the application for writs at the Supreme Court, there is you have a procedural issues and then you have a substantive issue. So you can argue that this thing wasn't filed correctly, it's improper on its face, it missed this critical thing, so it has a procedural defect. Or you can argue on the merits. Well, hey, they didn't meet the burden. The evidence doesn't support this. And both those things can be very important. And here they're making, I think, a pretty good procedural argument. That's why I'm repeating what I'm saying about it. And I'm going to say that because if you look down here, they're talking about purports to allege indirect civil contempt. And then they say, well, civil contempt is not the right situation here because it's not a remedy for the state. We didn't do something that you could give them some money for or something like that. You're saying we did all these terrible things. You're really talking about you want to punish us, and that is criminal contempt. Okay, so there's civil contempt, criminal contempt, but what I really want to focus on here is the indirect part, because indirect contempt is normally something that doesn't occur in the presence of the judge, right? So at least in this state, if you have a indirect criminal contempt, then the judge is supposed to deal with that differently than if it's direct contempt. So if it occurs in the courtroom, the judge can act right away on it, and you can be in big trouble. But if it happens in some other way, then there's really a whole separate way to proceed with that, an entirely separate way to proceed with it. And it's almost like a little mini trial because it's a criminal penalty. And you have to be found guilty, and you might even have a different DA. You might have a different judge. And that's what Allen's attorneys are saying here. So they're talking about to pursue indirect criminal contempt against these attorneys, the state would have to file an information in a separate criminal case, and it's not done it. And so they can't be punished for indirect criminal contempt in this case. I think that's a pretty good procedural argument. I'm not an expert on procedural law in their state. However, this makes sense to me. It does make sense to me that this is, remember we talked about, not just me, that one of the issues with what Judge Gull did with these guys is she didn't make much of a record when she threw them off the case. It was all kind of in camera, and then they came out and had a summary disposition in the courtroom, and there really wasn't much of a record. And procedure definitely can matter. For example, if Judge Gull had taken the time to write out an order that anticipated what the Supreme Court was going to say and say, well, I've considered lesser things, nothing else will work, this is my last resort, I've analyzed the cost benefit to the defendant, blah, 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 and all that. They might still be off the case because she would have anticipated the burden that the Supreme Court was going to come up with and made a record. At least they would have had to decide on the record whether she was correct or not. Well, this is a little bit like that. It's like you need to follow the correct procedure. And I'm going to be interested in what happens on this because, well, I haven't done much research on it. On the face of it, what the defense is arguing here makes sense to me, that this is not really the way to handle this kind of contempt hearing, but they are barreling toward it in March, regardless of whether I'm right or wrong and whether they're right or wrong. Oh, look, I did get a box on there. So that worked, but not the highlighter. And that's where I put on there indirect criminal contempt. It's what they're saying is really being attempted here, because that's not what they called it, of course, in their motion. So the judge will have to sort all of that out. And this is over basically the same sorts of things that we've all heard about. The statement they made before the gag order, the leaking of the evidence, potentially the discussion of it, and the expansive Frank's motion. I think it would have been better to leave all that in the rearview mirror and get on with it, because the judge has denied the Frank's hearing. If you're the state, that's what you wanted, and just move on with the case. But there could be more acrimony behind the scenes than I know about, and more going on. So just an opinion. So let's see here. State's notice and request for discovery cut off, so they want to know what the defense is going to say in this hearing for contempt. And they want to know by March 7th, which is interesting because this is about the electronic devices. This is just the defense. This is an attorney who's representing the defense attorneys for purposes of this thing. And he's saying, hey, I want to bring in, I think, a phone and a laptop that I can get to and use when it's appropriate. That seems reasonable. And then this is an interesting one. This is the notice of depositions in the case. So the defense is saying, well, if we're going to do all this, then we have a right to explore the evidence in this case and to defend ourselves. And so they want to take depositions of Jerry Holman and Ben Rector and Steve Mullen and Mitch Westerman. Okay, and they want to do it at the DA's office. They also have a separate subpoena, I think, to have them bring documents with them. I didn't read what all they asked them to bring, but probably everything potentially related to this. So that's interesting, and is certainly warranted by the defense. If you're going to move for contempt, the defense has a right to dispute it. And now we got a bunch of discovery going on in this case and depositions and things, all about what is kind of a sideshow issue, right? You can't unring the bell. The defense has done what the defense has done. Wouldn't it be great if the judge just said, listen, don't do anything else, all right? Because we can't unring everything that's been done. But if you do anything else, then I will look back at all this and consider all this. But for right now, can we focus on getting the case done? But that's not where this case sits. So, all right. And what about the speedy trial motion that was asked for by the defense at the Supreme Court? Haven't seen that yet. It's been a while. I don't know. Maybe they're not going to file it. And if not, I guess it's October-ish before we get to a trial and more drama with all of this pretrial stuff. So this is just a rundown of what has been going on in the case, that at least that I've seen, a quick look at it on the docket. And there's, as I say, there's some interesting things that you should see and should be decided, like this destruction of evidence stuff and all of that the defense brings up. That's normal if it occurs, to ask for that and to get it ready as you get closer to trial, to know what's going to be at stake and what's not, how to preserve issues for appeal in the event your client is found guilty. But there's also still a bunch of sideshow stuff. So that is going to occur in March. There may be some more filings before then, but depositions and then this hearing in March, where, look, the judge could find them in contempt again and use the Supreme Court standard and say, you know what, I'm going to throw them out again because I do think it is the last resort and I have considered all these things. I don't think that should happen, okay? I don't think that should happen. I think they should have to do something else. I mean, come on, the Supreme Court has put them back on the case, and if on its face they did something truly horrible, I don't think they would have done it. So that's why I say this is, to me, all a sideshow, that unless they do something else, I don't think this should be what they should be spending their time on. But we'll just have to see what the judge thinks about all of that. So anyway, that's it for this case, and I'm going to put it to the outro with new, or more original, not copyrighted music. Thanks. Bye.